Belinda McCauley, Executive Director of the Beverly Hills Bar Association, and I'm delighted to be here today to introduce our speaker, Lee Mendelson. Lee's a mediator with ADR Services, Inc. He has more than 27 years of experience and a strong focus on dispute resolution, particularly in commercial litigation, personal injury, insurance coverage, workers' comp, and subrogation matters. From 2006 to 2023, he served as the managing attorney of Mendelson Law Group APC and holds the Certified Subrogation Recovery Professional designation from the National Association of Subrogation Professionals. A frequent speaker and published expert, Mr. Mendelson brings a wealth of practical insight and leadership to his mediation practice, helping parties efficiently resolve complex legal disputes. And with that, I will turn the floor over to you, Lee.
Thank you, Belinda. And that was a great introduction. That makes me sound really good. Thank you so much. I'm going to talk just for a minute before we get started. Belinda hit on just about everything about me, but let me just to give you a lay of the land. As she mentioned, I was a litigator for 27 years. I sold my law practice and I mediate full time now. Mostly what I mediate are personal injury, products liability, premises liability. I do a good amount of employment mediation and just general business mediation. While I'm not doing that, I'm also an adjunct professor at Pepperdine University where I teach negotiation theory and practice. And I'm a total nerd when it comes to negotiation theory and practice. I love it. I am so happy that I learned more and more about it probably about 10 or 15 years ago during the course of my litigation career, because it helped me to successfully negotiate cases and to come to better resolutions because I understood the theories behind it. So what are we here to talk about today? We're here to talk about bias. What is bias? Bias is it's like a filter that goes in front of a person to stop them from making rational decisions. If I have a bias, I'm going to have an unfair or prejudiced way of thinking. And by prejudice, I'm not necessarily talking about racial or cultural prejudice. I'm talking about a way of prejudging things. I am looking at things from a gut feeling rather than from a rational feeling or rational thought. And I'm not thinking it through prior to making decisions. And so that's what we're going to talk about today. We're going to talk about bias. We're going to talk about how to see bias in ourselves and how to see bias in other folks. And by recognizing the bias in ourselves, I'm going to discuss how to recognize those biases and how to take that recognition and get rid of the biases so I can make a rational decision when I'm negotiating a dispute. On the other hand, I'm also going to say how to recognize the bias in other folks, so when I'm negotiating with someone, I can see, hey, they have this particular type of cognitive or motivational bias, and how I can utilize that, of course, always in an ethical manner, but how I can utilize that to help me get a better settlement for my client. So those are the tasks that we're going to do today. To start, let's look at the main different types of biases, the big categories that things fall into. And the first one is cultural bias. And that's what people think of most of the time when they think of bias. What is a cultural bias? It's a prejudice based on cultural norms or social expectations. That's what most folks think about when they think about bias. The other types of bias, and the ones that I'm really going to focus on more today, are cognitive bias and motivational bias. Cognitive bias are biases of the mind. There are these mental shortcuts, these quick gut decisions that we make when we're negotiating disputes. Motivational biases are emotional biases. These are what I like to call biases of the heart. And there's a great book called Negotiation Genius that outlines these different types of biases further. And I would recommend that you take a look at it, the cognitive and the motivational biases. But let's first go and spend a few minutes. Let's before we jump into cognitive bias, and we can just hang tight here on the slides. Let's talk a little bit about cultural bias. And what I'm going to tell you is there's a great book that I would recommend that you look at with regard to cultural bias, and it's called The Culture Map. It's by a woman named Erin Meyer. And what Miss Meyer writes about is where to find yourself on the cultural bias spectrum. She takes different scales like communication, feedback, leadership, and where do you find yourself on those scales, and where will you find other people on those scales, and how folks from different countries generally fall on those scales. So I'll take a couple of the things in the cultural bias handbook that she has written, and I'm gonna excuse me, take a couple of things from the cultural bias handbook that she's written, and I am going to outline them for you, tell you what countries most of those fall under, and where you can find yourself. One thing I would recommend also is Erin Meyer, the culture map, has a great website. I would recommend that you go and take a look at it because you can pay like $5 or $7, something like that. It's not a lot of money, and sign up for it for like a day pass and answer a bunch of questions, and then you'll find where you fall in the cultural map, and you'll find where you fall on these scales and be able to help you to recognize those biases in yourself. So, what are the cultural bias? And another thing, well, let me just talk about this and I'll get back to it. What are the main scales in the cultural bias? One is evaluating. How do you take feedback and how do you give feedback? Do you have direct negative feedback or do you have indirect negative feedback? So countries like the Netherlands and Russia, they are extremely direct in their feedback. They're going to give you negative feedback. People from those countries generally are going to give you straight negative feedback. And the important thing is to recognize that you're going to get straight negative feedback from those places and or from particular types of people, and to not be offended by it and be able to utilize it to do a better job with whatever conversation you're having, with whatever negotiation you're having. These people are going to be very direct with you. There's other countries that do indirect negative feedback. They don't come at you straight on. They come at you in a roundabout way. People generally from Japan and Thailand are very indirect with their feedback. They come in a roundabout way. And the thing about that that's important to recognize is you don't want to miss that feedback because it's going to make it more difficult to settle your case if you miss that type of feedback. So that's in evaluating. Let's go into leading. How does leading happen from different countries and from different perspectives? Are they more egalitarian or are they more hierarchical? What does egalitarian leading mean? It means it's a flat hierarchy. It's a consensus building situation. People lead by consensus mostly from like Denmark and Sweden. They're very consensus based cultures. But hierarchical feedback is a respect for rank. The boss is usually right with hierarchical feedback. When I ran my law firm for 27 years, I listened to everybody, but it was a hierarchical situation. People from India and China are very hierarchical. Same within the United States, actually. It's a very hierarchical situation. So when you're negotiating with those people, you need to make sure the boss is on the right page with you. But if you're negotiating with a large organization that's egalitarian, you're going to need to form a more consensus with all of the people you're negotiating with, the different parts of the organization. To me, that's more difficult, but sometimes it's not. Depends on who you're dealing with. Next is, how are decisions made in different cultures? Who makes the decision? How are the decisions made? What happens? Some cultures are very consensual in their decision making. That's in Japan and Sweden. Some are more top down. That's in the United States and China. Same kind of a situation as what we were talking about before. If there is a decision making process from someone in the United States, you have to convince the boss to make the right decision. The next one is trusting. how do people trust each other? Is it task-based trusting, or is it more relationship-based trusting? Uh, Task-based trusting is you trust a person when they do a good job. You look at how they did a good job on a previous task, and that means that you trust a person if they did a good job on a previous task. People in the United States are very task-based trusters. People in the UK are very task-based trusters. But on the other side of the coin is relationship-based trusting. How do we these people, like in Brazil and in Saudi Arabia, they are relationship based trusters. They trust you if they know you. They trust you if they know your family. You're going to need to spend time with these people. You're going to need to talk to these people about things other than the case. If you want to develop a rapport with a client in order to negotiate a deal later, and that client's from Brazil, for instance, you're going to need to negotiate, you're going to need to develop trust with that person by spending a lot of time with them, not dealing with your particular type of case. They're going to trust you as an individual attorney later. And then when you negotiate the deal with the other side in whatever dispute you're dealing with, they'll trust your decision because they trust you. Then there's disagreeing. How do different people disagree in different cultures? There is confrontational disagreement, and there is avoids confrontational disagreement. Israelis are direct and cultural, in their culture is very direct in disagreement. French folks are direct in disagreement. People that avoid confrontation are people from Indonesia and Japan are going to be very indirect, which means they're not going to come straight at you with whatever their disagreement is. They're gonna do something a little more nonchalant, a little more from the side. So you want to not miss their disagreement. You want to know that they're disagreeing with you, or else you're not going to get a deal. So you're going to have to pay really close attention to that and not expect them to be as direct with you, and you're not going to want to be as direct with them. Then finally, the last cultural bias that I'm going to talk about is scheduling bias. That is, some folks believe in linear time and some folks believe in flexible time. Linear time means punctuality, strict schedules. People from Germany and Switzerland are very into linear time. And then people with more flexible time are people really from India and Nigeria. Their goals are not going to be as much on a punctuality timeline. They're going to be flexible with their timeline. My wife and I, we get along great. We have a great relationship. But I am very linear with my timeline, and she is very flexible with her timeline. And that is the only place where we have disagreement. And I have to know that she is going to be flexible in the way she's going to show up to something. And she's going to have to know that I'm going to try to be really punctual. And when we know that, we get along great, and we work things out. So it's important to know those types of things. So now, and I do think that cultural bias is important in the cases you may see down in LA County Superior Court, and that you may deal with these types of biases on a regular basis. You're also going to look, and I did a lot about talking about different countries and the types of biases that come from different countries and those kinds of things. But to be honest with you, these are parts of egocentrism. These are parts of a definite motivational bias called egocentrism. It's the way I look at it from my personal perspective, from my point of view. And if I can get beyond that motivational bias, that egocentrism, I'm going to be okay, and I'm going to be able to do a proper negotiation. So let's move on and let's talk a little bit about cognitive bias. So we're on the slide here. Okay, cognitive bias. What are those cognitive biases? They are biases of the mind. Those are those mental shortcuts. Those are those decisions we make just with a gut reaction without thinking through to them. They're just like secondhand in our mind. The biases that are cognitive biases generally, and I'm going to go through these in just a minute, are fixed pie bias, the vividness bias, the non-rational escalation of commitment bias, and the susceptibility to framing bias. Now, before I get into that, let me tell you a little story about something that happened to me, I guess a week or two ago. So I'm a mediator. I'm mediating a case regarding a church. Uh, it was a very emotional case. Uh, this one religious institution, this one I'll call it religion. It's not really its own religion, but I'm going to call it its own religion. They didn't have a church in Los Angeles, and they wanted to build one. So 40 families got together. They raised a bunch of money, and went out to look for a piece of property. They opened up a 501c3. They opened up a nonprofit. It's a nonprofit organization to buy this church and to run the church, and they raised all this money, about $500,000, and they put it into the 501c3. They went to look for the property. Unfortunately, it was a brand new 501c3. It was a brand new corporation, and they couldn't get any credit. They went around and they just couldn't get credit. They found the perfect property that they wanted to buy, but they couldn't buy it because no one would make them a loan. So what did they do? Somebody from the church, a woman from the church, volunteered and say, "Hey, I can get credit. We can put the church property in my name." So they bought the property using the 501c3 money to buy this piece of property. But what they did was they took the money from the nonprofit, they gave it to this one individual church member, and she bought the property. She put it in her name. Every month for a year, she made the mortgage payments out of her own checkbook. But that money came from the 501c3, the money that had been raised by the church. So the church gave them money, the corporation gave the woman money, she paid for the church property every month. So unfortunately, over the course of a year, there became some real dissension in the church. The person that they had hired to be the religious leader, a big chunk of the church did not like the way he was teaching that spirituality, the way he was teaching that religion to the parishioners and to the kids and to the families in the church. So out of those 40 families, I would say about 30 of them didn't like the way they were running the church, and about 10 of those family units did like the way they were running the church. The 30 that didn't like it, unfortunately, the woman that actually owned the church property was in the minority. She was in the 10 that liked the way they were running the church. Also, the great chunk of the money that had been raised by those 10 people, those 10 family units that liked the way that the church was going. But the majority of the church goers, the majority of the members, the people that I'll call the corporation folks, they did not like the way the church was going. So anyway, what happens? The people from the corporation are no longer going to the church. They stop paying the bills, and they file a lawsuit against the woman that the property was in her name to get all of the money back that they had given to the church. So let's move on to the fixed pie bias. Let's go to the next slide here. Okay, what is a fixed pie bias? It's a focus on what's called distributive bargaining while ignoring what's called integrative bargaining. So let's go to the next slide here, and I can explain the difference between distributive bargaining and integrative bargaining. Distributive bargaining is claiming value. If you are a distributive bargainer, one side wins, the other side loses. It's a zero-sum game. Integrative bargaining, on the other hand, creates value. It seeks ways in which both sides can obtain their goals. It looks for the lowest cost to make sure all of the goals are obtained. The pie is expandable. You can grow the pie. We're not just talking about that one thing that we filed the original lawsuit about. What we need to do in integrative bargaining is focus on interest, not on positions. So let me get back to the church. Let's talk about what the problems were with the church and what they were focused on. They had very much of what I would call a fixed pie bias. They were very upset and very focused, the corporation people, on getting that money back. That's what they were looking for. They filed suit for that money. They wanted to distributive bargaining. They wanted to claim value and get as much of that money back as possible. They wanted the other side to lose. They wanted them to be out on the street. They wanted to get their money and move on. It was a zero-sum game to these people. The defense was the same way. She was like, these people are total jerks. They're trying to mess up our church. If we pay them all this money, we're going to lose our church. There's no way. We're totally focused on the money. So what did I have to do in this mediation? I had to talk to these folks and find out not their positions, not where are they set in their positions in the negotiation. One position, I want the 500,000 back. The other position, I won't give you the $500,000. What we needed to focus on is what they were really interested in. Why did they raise this money to begin with? Why did they want to do this in LA to begin with? They wanted to provide a church to their kids, to teach their religious beliefs, to have life cycle events for their family in that church. They wanted to have a place to worship and to be together and to fellowship and to do those types of things. So that's what everybody wanted, both sides of it. That's what they really wanted. So I had to spend probably a good hour or two getting down, letting them emote their feelings and say why they were so upset about the money, to get down to the point of what were they really interested in? What did they really want? And then at the end of the day, I explained to them that they had this fixed pie bias. I didn't straight out say it, but through a series of questions, we're able to get to the point to, hey, you're focused on the wrong thing, because if they give you all of this money, you're still not going to have enough money, and you're not going to have the credit to go buy a new church, and they're not going to be able to keep their church. Nobody's going to have a church if you do that. So we have to figure out a way to do it. So what did we do? There was an exchange of money that took place, but mostly the agreement was based on ownership of the property, and more than even ownership, it was based on use of the property. So they kept the church. They used one religious leader for church services during one part of the day. They hired the corporation people hired another religious leader for services during another part of the day. They were able to use different parts of the church, and that's what they did. So we're able to come to a resolution by overcoming the fixed pie bias. So let's go to the next slide here. Vividness bias. That is paying too much attention to vivid features while focusing less attention on less vivid features. So what do I mean by that? So in most cases, and also I'm going to go back to one thing I want to mention really quickly about the fixed pie bias, and this is the same true for the vividness bias. There are a whole heck of a lot of cases where it is just money, and that's it. And, I know that, you know that, we all know that. A lot of times it's just a payment of money, but a lot of times it's not. Especially I see that in the employment cases that I do. I see a lot of, here's this employee that's worked for this small business for 25 years who's now suing the small business on a wage and hour claim or something like that. The small business is like, hey, I employed this person for a long time, and they're suing me because I didn't properly notate their lunch. And then the person that's suing them, the employee's like, hey, I worked for these guys for 30 years, and they never gave me time to eat lunch. I mean, these are very emotional types of situations that you can't just be focused on the money. You have to focus on other things in order to get them properly resolved, and look at the emotions and let people vent them. So anyway, what is vividness bias? That's paying too close attention to vivid features. And I'm going to give you an example so you can know what vividness bias is. It's the Eitan Patz case. A lot of you probably, people that are like my age, I'm in my 50s. I was in prime time when the Eitan Patz case came about. It affected my childhood, and I think it affected, especially more in New York City, it affected their people's childhood. He was a kid, 6-year-old kid, cute little blonde-headed kid that was lived in Soho in New York City and walked to the school bus every day. All of a sudden, one day, he disappears when walking to the school bus. Kid is abducted, never seen from again, and that's it. All over the news, wall-to-wall coverage of this kid, all over the place. Because of this situation, when I was growing up, if you sat down for breakfast and had milk in your cereal, you would look at a milk carton and there would be a picture of an abducted kid. It was talked about a lot. There were seminars for parents on it. It was a major thing. and kids moved further away from free range childhood to going to events that were supervised and everything. There were more helicopter parents, watching the children. And it wasn't like play until the lights go out. Like until I got to about 10 or 11 years old, it was more of go to practice and have a supervising adult that's being paid to watch you while you're there. Those kinds of things changed, in a lot was because of the Aton Pats case. The problem with the Aton Pats case, and the problem on the laser beam vividness, the laser beam focus on this one particular case, is child abductions by strangers are extremely rare in the United States. They are very rare back in those days, and they're very rare today. I'm not saying it doesn't happen, and it happens a bit, but it's not a widespread problem all over the country that happens all the time. And people were very vivid, people were very focused on this case, and it clouded their rational decision making. Parents were very clouded by their rational decision making. This happens in court a lot, and good litigators know this. And that's why they depose a lot of witnesses. Sometimes it's to get information. It's always to get some information, but a lot of times it's to see demeanor. It's to see how good this witness is going to play in court. Because like I said here, an example of the vividness bias, of course, is the jury is going to be swayed by an emotional victim. The jury will be very swayed by an emotional victim rather than by the dry forensic evidence. If I put a forensic accountant on the stand to ask him a bunch of questions about what happens in the checkbook, it's not as convincing as the vividness of that emotional victim. When we negotiate with people to resolve our cases, we can't be focused on the vividness. We have to be rational in our decision-making process. Let's go to the next slide. Okay, next slide here. Oh, non-rational escalation of commitment. What is non-rational escalation of commitment? What are the steps to that? You make an initial investment, you get negative feedback, but rather than when you get that negative feedback, you escalate. You don't pull out. You continue to escalate, and it is completely non-rational, but it is done all of the time. Let's go to the next slide here. What are some examples? The best example of non-rational escalation of commitment is gambling. You go to the casino and you sit down at the $10 blackjack table, make your first bet, you lose. Make your next bet, dealer comes up with 21, you lose again. Make a third bet, you lose again. So now you've bet three $10 hands. You've lost all three $10 hands. What do? The smart person, the rational person, would walk away from the blackjack table. The non-rational person, which is, listen, I'm going to tell you right now, I own a house. It's a nice house. I don't own a whole big, massive building like the MGM Grand. There is a reason why they own it, and it's because of non-rational escalation of commitment. What most people do, what a lot of people would do after losing those three $10 blackjack hands is, oh, I'm going to bet $30 and get my money back. That's how you lose. That's non-rational escalation of commitment. It happens in business projects quite a bit. People put more money into a real estate deal when it looks like it's going down rather than when it's going up because they want to double down on what they believe in. It happens in war, of course. It happens at the negotiation table, obviously. It happens a lot in personal relationships. I don't know how many people here are family law litigators. But if you are a family law litigator, you have seen, especially if you're doing, obviously, mostly if you're doing divorce or child custody things, you have seen where there is abuse in a family law situation. And for many years, rather than leave a person who is abusing their spouse, the spouse stays and escalates. They say, oh, he's just abusing me because I'm not doing X, Y, or Z right. I'm going to double down on that. And that's non-rational escalation of commitment. It's a bias that that most of us have. We have to recognize it. Next one, please. Susceptibility to framing. People are influenced by tone. Uh, people are people are influenced by the way you say things to them, not necessarily by what you say. I've learned this, I have three daughters, and I've learned this a lot with my kids, the way to lay things out, the way to frame a situation in order to avoid dispute and to get compliance. People tend to avoid losses more strongly than they seek gains. People are more loss averse than they are to seeking the gain. People rely on these types of mental shortcuts rather than analyzing the data. People will make snap decisions rather than analyze the data. Let's go to the next slide. What are some good examples of susceptibility to framing? The offer discount. If I'm going to give you 10% off, it's more appealing than if I'm going to charge you a surcharge of 10%, obviously, right? It's going to be the same price. It doesn't matter. It's the same price. But the way I frame it makes a difference. A hamburger is 75% more lean sounds a lot better than a hamburger has 25% fat. Susceptibility to framing. I'm going to give another example. This is a case I mediated last week. It was a fee dispute for an attorney that filed suit against her former client, family law case. This attorney did not have good documentation. She did not have a signed fee agreement. There were a lot of problems with this case. She didn't have a signed fee agreement. She had a fee agreement, but she couldn't find the signature, the signed copy. The other side claimed there was no signed fee agreement. She waited too long. It was within the statute of limitations, maybe, if you use that COVID exception to stay in litigation, but it was maybe not. There were a lot of problems with this person's case, but that family law attorney had done a heck of a lot of work for the client, and the client owed her a chunk of money, right? The family law attorney, first of all, let's talk about how the defense attorney operated. The family law attorney framed the case as she was owed $50,000. She wasn't owed this is a small case. She wasn't owed $50,000. The defense attorney framed it as, hey, not only does my client not owe you that much money, you don't have a fee agreement. I'm going to go to trial and win on the merits because you don't have a fee agreement, and you may even be outside of the statute of limitations, but I'm going to win on the merits. I'm going to win on the fact that you don't have the written fee agreement. And after I win on the merits, the defense counsel said, I'm going to sue you for malicious prosecution. So the susceptibility to framing in this case was, hey, attorney that thinks they're owed all this money, not only are you not owed all this money, you're going to be sued for malicious prosecution. And at the end of the day, the case, they ended up paying a little bit of money to that attorney. And I felt bad for her because, hey, listen, I'm a lawyer. I want to see other lawyers get paid for their services. But you have to dot your I's and cross your T's and do the right thing, or else you may not get paid. And it was upsetting. It was an upsetting situation because I really liked her and I really wanted to see her get paid. But it was not something that. But also, she was afraid that she was going to get sued, and she was probably rightly afraid because I do think this defense counsel was going to do it. So anyway, let's move on to the next slide. Motivational biases. Okay, so we talked about cultural bias. We talked about cognitive biases, which are biases of the mind. Let's talk about motivational biases. These are biases of the heart. These are things that we do emotionally to see things through, not necessarily things that we do in our mind, but things that we do through emotions. The types of motivational biases that I'm going to focus on are conflicting motivations, egocentrism, optimism bias, self-serving attributions, and what's called regret aversion. Okay, let's move on to the next slide. Okay, conflicting motivations. Short term versus long term. What does that mean? Of course, that's I want to eat a piece of cake today, but also I'm trying to lose weight. Those are conflicting motivations. Self interest versus fairness. When I was a client, when I was an attorney and I represented clients, I was aggressive in self, and I was very focused on the interest of my clients, zealously representing my clients. But I also wanted the deal to be fair. I wasn't trying to do anything unethical. I wanted to make sure it was a fair deal, and those are conflicting. Those are conflicting motivations that I had. Today, obviously. I aggressively represent the deal. I want to see the deal happen, but that's not what I did back in those days. Uh, Avoiding conflict versus expressing truth. A lot of reasons why we end up in litigation to begin with is because people avoid conflict early on. When the conflict arises, they don't express truth. They just continue to avoid conflict. And then eventually it all boils over. It goes to a crescendo and they have to file suit. And then they're willing to talk their truth. And I spend a tremendous amount of time with people in my mediations saying, hey, you need to say this, not in an unkind manner, not in a way to insult someone, but you need to say it in a way that tells the truth of what the way you see things and stop avoiding the conflict to move forward. Compliance versus autonomy. That's another conflicting motivation. I see this a lot with my kids. I have three teenage daughters in my house. They're good girls and they want to be compliant with things, but they also want to do their own thing. They want to be autonomous. That's a conflicting motivation that I see all the time with them. And then, of course, with security versus opportunity. That's the old thing of, do I stay in the secure job? I'm making enough money. I'm getting by. I'm able to pay my mortgage. I'm doing okay. I don't have fun at work. I'm not ever going to get that big payday, but I'm okay. I'm not necessarily happy, but I'm doing all right. Versus that opportunity out there. It's a big risk. You may totally lose everything. It may not be worth it, but it may be a great thing. Those are conflicting motivations. Let's go to the next slide. Egocentrism. Of course, we all know what egocentrism is. That's when we're focused on our own perspective, and I have a difficulty understanding the views of others. I'm so focused on my own perspective that I can't see uh, how to deal with things directly. Let's go to the next slide. How does egocentrism cause problems in negotiation? Biased fairness perceptions. I think what's best for me is fair. Uh, and it may not be best for you. And that's going to cause a big problem in negotiation. It's going to prevent a settlement. Overestimating how clearly we communicate. There's a lot of people that are egocentric people that think they said it and the other person totally should understand it because there's no other way for them not to understand it because I said it correctly. That's egocentrism. Communication. If we're not communicating clearly and the other side doesn't understand what we're talking about, we're not going to settle a case. Misinterpreting other people's behavior. With egocentrism, I think everything that you do has something to do with me. If you don't respond to me when I ask you a question, it's because you are being rude to me. It's not because you have seven other things going on in your life that you have to deal with right now, and it has nothing to do with me. Most things don't have anything to do with Lee Mendelson. That's egocentrism. I have to get over that to know that and move forward. Failure to anticipate reactions. If I'm egocentric and I'm focused on the way I think about things all the time, I'm not going to see your reactions to things. I'm not going to understand the way you react to things because I'm only focused about it through my lens, which is I'm not going to be able to settle the case. Let's move on to the next slide. Optimism bias. This is where I think good things are more likely to happen to me and bad things are less likely to happen to me. If I have the optimism bias, which in a lot of ways I am a pretty optimistic person and I don't think that's a bad thing overall, but if I do have the optimism bias, I'm going to be oh, okay. If I do have the optimism bias, I am something popped up on my screen. I apologize. If I do have the optimism bias, I'm going to be I'm going to have an illusion of superiority. I'm going to be overconfident because I am so optimistic things have to go my way. And if I'm overconfident, I'm going to not, I'm going to miss the ball and I'm not going to see what happens. Let's move on to the next thing. Self-serving attributions. That's when I believe everything goes right because of me, everything goes wrong because of you. And that's how we end up in a lot of litigation too, because of that. Some of the, I put on here some examples of self-serving attributions. And like I said, I have 3 daughters and I hear this. If I get an A on a test, it's because I studied hard. I worked so hard. That's why I got an A on a test. If I got an F on a test, that teacher's unfair. That teacher, he doesn't know what he's talking about. I can't believe he gave me an F. We see it the same way in court. And, I had quite a few associates that have worked for me over the years. When those associates came in and told me they won a motion for summary judgment, it's because they made a strong argument. That's why they won the motion. When those associates come in and tell me that the motion did not go their way, that's because the judge was out to lunch, man. That judge didn't know what he's talking about. He didn't understand the issues. That judge just doesn't like me. He likes the other person. That judge was biased. Those are self-serving attributions. Okay, let's go to the next slide. Okay. Regret aversion. That's when regret aversion is making a decision to avoid future regret rather than use rationality to make the decision. I cannot tell you how many times this is especially true when cases get sent to mediation when one of the parties does not want to mediate. When cases get sent to mediation and one of the parties does not want to mediate, a lot of times they're doing it because they think they're going to settle the case too soon if they mediate now. A lot of people that don't settle the case because they think they're going to settle the case too soon. I've noticed this is more just my personal what I've noticed in life. I don't have data for this. This is just what I've noticed in life by talking to a lot of people that have, when they decide not to settle a case because they think they're going to settle it too soon, they come back later and I help them settle the case, but I'm not able to get them as good of a deal as I would have gotten them earlier when they thought they were settling too soon. This is regret aversion. You don't want to have to regret it later. Basically, if I make this decision now, I'm going to regret it later. These are all biases that we've talked about here. These are all things that are blocking us from making rational decisions. How do we overcome these biases? How do we make rational decisions without being biased? That's what I'm going to talk about next. Let's move on to the next slide. How to avoid being biased. Okay, we can move to the next slide after that. System 1 versus System 2 thinking. System 1 thinking, those are gut reactions. Those are making quick decisions on the fly based on feeling. I'm going to tell you, probably for the first 10 years of my practice in law, maybe after the first couple of years, I got used to it. A year or two, I got used to it. And I thought, hey, I can make this. I can look at any case. I can make a quick decision. I know where this case should settle. I don't need all this other information. I can see it and I can make a decision quickly and get it done. Those are gut reactions. Those are System 1 thinking. Once I started studying negotiation and understanding the theories of negotiation, I realized I really need to become more of a System 2 thinker. I need to pause and reflect before I make a decision. I need to write out pros and cons. I need to use checklists and decision trees in order to make decisions. Sometimes I don't need to make that decision today. I need to sleep on it. I need to think it over. That's why a lot of times it seems like in mediations, it's becoming more and more common that people want me to give them a mediator's proposal. We mediate the case, we argue, I listen to both sides. I see where they're going with the case. And then they ask me to give a proposal of how I think the case should settle. A lot of times that's just so they can get a minute to think about it. They've already come. I let people kind of know where we're going with the case and where, if I do give a mediator's proposal about the way it's going to be, they understand that before I give the proposal, but they want a minute to sleep on it. And I think not always, sometimes you should make the decision today. A lot of times you should, but there's also a good amount of times where you need to sleep on it. You need to think about it. This is system two thinking. Let's move on to the next slide. Pre-negotiation analysis. This is crucial in negotiation. You must prepare prior to a negotiation. It's if you want to get to a good result, if you want to not be biased during the course of the negotiation, if you want to not let these bias, this emotion, these cognitive quick decision biases affect you during the course of negotiation, you need to do proper pre-negotiation analysis. There's a 5-step program to pre-negotiation analysis that I teach this in my course, and I'll go on and on about it for at least 2 hours, but I'm going to do this in about 5 minutes, okay? Assess what's called your BATNA. What is your best alternative to a negotiation agreement? What would you do if you don't reach an agreement in your negotiation? That's your BATNA. Then you have to assess, you have to determine what's called your reservation value. What is your walk-away point? Your walk-away point is not your BATNA. It's not your best alternative to a negotiation dispute, because you may want to walk away prior to going all the way to the best alternative. You may want to walk away before that, and that's your reservation value, and you have to figure out where that's at. Then you want to look at everything. You want to look at all of the documents. You want to look at all of the, deposition transcripts. You want to look at all the motions that have been filed. You want to look at the pleadings, and then you want to try to determine what is the other party's BATNA. What do you think the other party's best alternative to a negotiated agreement is going to be? After you've done that, you want to determine what is the other party's reservation value. How are they going to walk away? When are they going to walk away? What is the other party's walk away point? Which, like I said before, is almost never the same as the other party's BATNA. It's at a different scale. You generally want to walk away before you reach your BATNA. And by looking at this, by analyzing this information, you're going to come down to what is the ZOPA. What is the zone of possible agreement? The zone of possible agreement is that area between my reservation value and your reservation value. It's the area between my walk-away point and your walk-away point. Once you determine both sides' walk-away point from doing proper pre-negotiation analysis, you're ready to find the zone of possible agreement, and then you want to bargain in a way that the negotiation goes where you settle for something closest to their reservation value. You want to settle within the zone of possible agreement in a place that's closest to the reservation value, closest to the walkaway point of the other party without letting them walk away, and that's how you get the best deal. Let's go to the next slide. Okay. We've done our pre-negotiation analysis. We know the zone of possible agreement. We're ready to go in there and get this case resolved. I'm not going to let bias go in front of me because I'm being a rational person. I've thought this through. I'm in the negotiation, and the other side starts bringing up things that I've never heard of before. This always happens. Not always. This happens 75% of the time in mediations. It seems like something comes up that the other side, I never heard of that before. They may have heard of it, but it wasn't on top of their head. I've never heard of that before. How do I deal with that? When that happens, you have to, the old thing with Reagan and Gorbachev, trust but verify. When somebody gives you information that you haven't heard before during the course of a negotiation, you want to see the documentation. That's always my first question, if there is documentation. You want to see where they're coming from, and you want to understand it. You want to listen to the other side in a negotiation like a therapist. I've read a lot of books on therapy and how therapists operate, and I highly recommend that you do the same. There's a great one called what's it called? I'll find it. It's about disagreement is in the title. I'll find what it is. But Difficult Conversations. It's called Difficult Conversations. Great book. You need to listen like a therapist. You want to hear the other person. You want to be able to not talk so much. You want to listen. You want to pay attention to what they're telling you and what they are not telling you, where they are coming from. Find out what their bias is. This person overconfident? Is this person egocentric? Have these biases that we talked about written in front of you while you listen to what these people are saying, and say, oh, this guy, he's very he's afraid of regret. He's that's what he's going to base his decision making on, is he's afraid of regret. You'll understand the other side. You listen like a therapist, and as you do this, as you're in the process, and this is the difficult part. This is the art of negotiation. Before, when I'm talking about pre-negotiation analysis, that's a science. The art is being able to reevaluate your pre-negotiation analysis during the course of the negotiation. During the course of the negotiation, you want to see maybe that person has a different reservation value than I thought it was. And if they do, you may be able to get a much better or much worse agreement today than you thought you would. And your zone of possible agreement may grow, or may shrink. And if you do think that the reservation value on the other side has changed a lot during the course of a negotiation, that's where you're going to want to rely on that system two thinking, and you might want to take a day and think it over before you make a decision. Let's move on to the next slide. Scoring. Highly, highly recommend scoring. So let's go back to the church example, where the two church parties were suing each other, where the corporation from the church was suing the entity, that the people that actually owned the church building. They were just talking about money, and that's all they came in there talking about, right? And it took me a very long time to get away from money. But if they would have looked at what they were actually interested in and scored it, given a number value from 1 to 100 on their interest, they would have realized that owning their own church property was a high place to score. But the biggest place to score may have been having a place to have worship services, not necessarily owning a place. And actually getting money back in their pocket was pretty low down, because just getting the money back in their pocket would not have allowed them to have a place to have their church services. So that was actually a lower place on the scoring scale. My oldest daughter just applied for colleges. And when she applied for colleges and she was making her college decision, I recommended that she use the scoring scale for different aspects. How is the location of the college? What do they teach? The kind of stuff you want to learn about? Do they teach it in a way that you want to learn it? Score those things to make your decision. After you've scored those things and you're in a negotiation, you can use that score to calculate your BATNA and your reservation value, and you can use it to try to score the other sides. So let's go to the next slide. How to utilize the bias of the other side. We've talked about that quite a bit. Well, let's talk about that a little more. One thing is framing. This is huge, okay? How do you make your first offer? Now, I do a lot of personal injury cases. And in those personal injury cases, I'll talk to the plaintiff's attorney and I'll talk to the plaintiff, and we'll try to get an offer from them. And 8 out of 10 times, the initial offer is whatever the insurance policy limit is for the defendant. If the defendant has a $5 million insurance policy, that's the offer from the plaintiff. It's not always, that's the initial demand from the plaintiff. Why? They want to anchor the case. They want to put it at a certain number value in order to resolve it. They want to start high. I had a case not too long ago. Well, I'll tell you, even that attorney fee case, that they didn't get a good settlement for it, but she tried to anchor it at like $50,000 when she was probably only owed about $15,000, to be truthful. This was a small case I was doing as a volunteer, but it was a good one. It was interesting. So anyway, she tried to anchor it high. She didn't succeed. But a lot of times when you make your anchor and you anchor it in a specific spot, you can get it. You can negotiate. I had a dog bite case not too long ago where in the dog bite case, the plaintiff anchored very high they made a first offer that was very high. And I have to tell you, I was very surprised that the defense came to the table and made it. Once they heard that demand, they came to the table at a much higher first offer from the defense than I would have expected that they were going to get. Another way to frame things is based on loss aversion. We talked about this a lot earlier about how people, are more afraid of loss than they are of getting. They're more afraid of loss than they are excited about getting gain. And if you frame your offer in a way of loss aversion, like the defense counsel did in the attorney's fees case, the defense counsel said, "Hey, attorney, that you're suing your former client, but you don't have a fee agreement for your former client. Not only am I going to win on the merits, I'm going to sue you for malicious prosecution afterwards, and you're going to end up paying my client a lot of money because of that." They framed it in a way of loss aversion, which in that case, it was ethical. It was smart, and they were able to get a good deal because of it. Let's go on to the next slide here. We're getting close to time, but I'm going to zip through these last two slides. Egocentrism. You want to validate the other's perspective. If somebody, after you've listened to them, you listen, listen, listen. I can't say there's two things that if you get anything out of this today, I want you to hear prepare, prepare, prepare prior to a negotiation. And then once you're in a negotiation, listen, 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 and listen for that person's egocentrism. Where are they egocentric? And you want to validate their perspective. You want to validate what they say. Everybody wants to be heard. Everybody wants to be validated. It's incredibly important for folks, especially in more emotional types of negotiations. In employment law, it's really important to validate the other person's perspective and understand it. And then from there, once their perspective is validated, they're usually willing to come to the table to talk to you. And I put in here, I understand that you want X, but here's my offer that can make that happen. And it may not happen in the same way that you want X, but I can try to make it happen for you. And then the last thing that I'll talk about here is optimism bias. So everybody wants to feel like they're the winner. Everybody wants to win. And there's a lot of people that come into negotiation. This is especially a lot of people that are not sophisticated. Most people that are unsophisticated negotiators, most people that are not as sophisticated litigators are focused on winning. Let them feel like they won. Let the other guy feel like he won. As long as my interests are met, I'm happy. And a lot of times I can let them feel like they win and give them that, and I get all my interests met, I'm ready to go home. So to keep my perspective, to know what my interests are, to write them out, to know what my pros and cons are, and then try to get those interests while letting the other side feel validated and feel like they won, I'm able to get my interest met and I'm able to move on with life. Okay, that's all I got. I don't know if there's time for questions or if there are any questions here. I haven't take. Oh, are we still here? Yeah.
Yes, we're still here. It looks like we have a couple questions. Shouldn't be too much time. We have one from a Ashley McCurchin asking, do you recall the name of the book or author recommended earlier when you were discussing cognitive bias? It's a female author.
I'm talking.
Do you,
cultural bias.
I think cognitive is what the asker is.
Cognitive bias. A great book for cognitive bias is Negotiation Genius. There's also it's called Negotiation Genius. It's from a Harvard Law School professor, actually sitting on my desk here, Max Bazerman. That's a great book for cognitive bias.
Okay.
Looks like somebody's asking about reservation value. Is reservation value essentially the thing they most want to avoid that would make them walk away from the deal? If not, can you help? Okay. It's not necessarily, it's just your walk away point. Reservation value. It's like, okay, my best alternative to winning to winning at litigation. Sometimes my best alternative is to continue. My best alternative to a negotiated agreement is to just continue the litigation, right? But that's my best alternative. But my reservation value might be, hey, I'll walk away if I get $100,000 on this case. I'm not going to be happy. It's not what my client wants. It's not what I want, but it makes a heck of a lot more sense than spending all the money on this litigation. So my walkaway point is the reservation value. That's the reservation value. I hope that makes sense to you. Also, can you tell us about the class you teach and where we can find it? I teach at Pepperdine Law School. It's in the dispute resolution, Strauss Center for Dispute Resolution, and it is a part of the LLM and law school curriculum. And a lot of kids a lot of students actually from the business school take it too. So if you're enrolled in Pepperdine, I'm pretty sure you can enroll in my course. And the book for cultural bias is The Culture Map by Aaron Meyer. And somebody asked how long I volunteered as a mediator before I became one. I think it's all, listen, that's a little bit outside of the subject, but I'll tell you, in my estimation in life, volunteer, get out there and do everything you can do to get the experience for what you want to be. And then people will eventually see, hey, this person is what they say they are. They have learned what they can do. And, and also I still volunteer. Like I was talking about that attorney fee case. I mean, I got paid on it, but not a lot. It was kind of through a volunteer program, and it was like a volunteer with a small payment kind of a program on that attorney's fee case. And it was, I get a lot out of that. I feel good about it now, and I'm going to mention this since we're talking for the Beverly Hills Bar Association today, and I'll wrap it up. They have a great volunteer program that you can volunteer for if you want to learn how to be a mediator. I think they do the mediation training, and they also have a great program, and most of that is on attorney fee agreements, from what I understand. But anyway, thank you so much. I appreciate everybody being here today, and that's all I got. I can be reached at ADR Services if anybody ever needs me. If you have any questions, you can look me up on the ADR Services website. I'm happy to answer any questions or talk to anybody about the stuff. I love it. So anyway, take care. Thank you so much.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.